Hi, this is Curt and welcome to another edition of Fire Law Roundup.
So we're going to start. Look, we got some really good issues this week. We could spend 2 hours on every one of them. I don't know if I always say that, but we want to start in Washington. Now, let's be clear. This case is national in its scope. So if you're thinking, well, I don't live in that state, doesn't matter. This is a national issue. And this is a big issue, not just for paid on call departments, but for any department that provides any type of incentive, bonus, productivity payments, etc., including length of service award programs, although you'll see that's not specific here, but any department in any state who provides any benefits, right? How broad can I make this? Has to be paying attention to this issue. This is not a new issue, but this is a big development. And you will see how complicated the analysis is. So here's what we have. In Washington, we have two persons who perhaps were initially believed to be volunteer firefighters. And of course, what happens is they get terminated. And as you know, everybody's willing to waive and not push all sorts of rules or issues when things are good, when somebody's hired. But the moment you terminate somebody, they're going to pull out all the dirty laundry they can. Why? Because they're pissed. So that's, presumably what happened here. So these volunteers, quote unquote, volunteer firefighters were terminated. And now they say, wait a minute, we're owed a lot of money because there are a couple laws at issue. First law is you have to pay all employees at least minimum wage. And if you go over 40 hours in a week, you have to pay a work week, pay period. You have to then pay them overtime or time and a half. And you have to pay them for all of their time. You cannot be volunteer for some and paid for others. So the primary question in this matter was, are these individuals employees or are they volunteers? Now, the facts are not that complicated. They were paid $100 for working a 24-hour shift and $50 for working a 12-hour shift. So now that's $4 an hour, right? Minimum wage, I think federally is what, 7 something.
In Washington, it's even higher. So
yeah, and New York is higher as well. Yeah. So, but one thing to point out is this is specific. You work an hour, you get paid for an hour. Very different than paid on call, where when you're needed, you come. This is you're standing by and being paid for shift time. Very important fact.
But Brad, a really key thing is the Department of Labor has said repeatedly in opinion letters that per shift pay is okay. And now they reverse themselves, and that's the thing that is blowing my mind here is that the Department of Labor has said repeatedly, not just once, repeatedly, in crystal clear terms, per shift fees are okay, as long as they're less than 20%. And here we have a federal court.
Obviously, go on.
Yeah, well, here we have a federal court going in the other direction. And in addition, they're suggesting, and I didn't read the whole record, they're suggesting that the Department of Labor already weighed in on this particular case. So I'm assuming the young firefighters, I'm assuming young, okay? They went to, the 2 firefighters who got fired, went to the Department of Labor first, and the Department of Labor said, you're definitely employees. And now the court is going to kind of go in afterwards and say, yes, the Department of Labor was right. But how can you have a history of saying per shift fees are okay, and all of a sudden you're going to go, well, they're not going to be okay. And this is a problem for folks who, like myself, who give clients advice based upon what the DOL has told them. Now we've got to go back.
I would weigh in, though, to say that there are other things at play here. So maybe it was maybe it was
and I wish the court had emphasized those, because I think a strong argument can be made that they went over the 20% minimum threshold. And the court should have just hung their hat on that. But oh no, they couldn't do that. They've got to raise questions unnecessarily about the shift stipends. And that just, it complicates things.
Right. But they have language on that. So let's keep going a little bit more, and then we'll beat up the court a little bit, or the Department of Labor.
Yeah, let's beat up the court.
Yeah, one or the other.
3,000 miles away.
Right. So additionally, the firefighters received payments on a point system as long as they completed certain activities. And going back to the shift work, they also performed what the court called detail work, right? But they got paid money at $15 an hour and $20 an hour for standing by events like at a racetrack, right? We do that a lot at football games and things like that. So they get terminated to file the complaints. The U.S. Department of Labor concludes they were employees. And this is, Curt, where you're going, which is a little shocking, but maybe it's a conglomerate. Maybe it's both the factors. In any event, so the court talks about 4 major categories, right, to evaluate this. And it's all a case-by-case basis, which is never never where any attorney wants to be in. Well, it could go either way, right? So there are 4 factors. So first, the court evaluated whether the individuals were primarily motivated by a civic, charitable, or humanitarian reason, or rather they just sought compensation, right? Were they truly volunteers, or are they truly looking for money? I hate that factor, but we'll talk about it. Then whether the compensation is in excess of what 20% of the prevailing wage was. And Curt, when we get there, if you could kind of talk about the rule, because that's really one of the big ones, right? Third, whether the compensation is based on productivity, in that the more you work, the more you receive. And the fourth one I completely disagree with, but then the court says, well, look, they're going to look at the number of hours per year and per week, and whether those number of hours are more consistent with employment or volunteering. And just to jump to that, they said, look, these guys did 50 hours a week, 3,000 hours a year. And they said that's more consistent with employment than volunteering. I think there's a lot of volunteers who would, disagree and call the court naive.
Absolutely. Yeah.
Right. So the court looked at a lot of things, right? And they really did. And they recognized, look, nominal fees, right? Less than 20% of prevailing wages. They quote the DOL, right? That says a willingness to volunteer for 20% of the prevailing wage for the job is a likely indication of the spirit of volunteerism, right? Right. That really is part of the FLSA, to allow people to get paid a minimal de minimis fee. I think we've seen, and if it's such a minor fee for the hours worked, hey, you're going to be a volunteer. But here they said, yeah, but you've been working for more than 20% of prevailing wage, and that's indicative of an employment relationship. So they really do look at the hours worked and the pay in exchange for the hours. And the Department of Labor came out, I just disagree with this. It's unlikely that 3,000 hours of service, whereas a paid firefighter would do less than that. They said, that's indicative of employment, not volunteering. I just can't tell you how many volunteers right now are saying that's just not fair. That's not right. We volunteer at least that number of hours. And then the Department of Labor, which the court says, listen, the DOL gets to interpret its own regulations. And this is where, Curt, you're really focusing. And I agree with you. I'm a little shocked. But the court says the DOL has interpreted its own regulations to determine that to the extent the payments are tied to productivity, for example, you get hourly wages for services rendered, then that's similar to a piece rate or a production bonus. And if it's tied to if your activities are tied to a productivity, then it's more likely that these fees are not nominal and that they're actually more like wages and salary, and you're more of an employee. So we'll focus on that in a minute. And then they took a lot from what these individuals said, right? What they testified. They said, well, wait a minute, we were doing this for money. This was a primary source of our income. We relied on this income, and we weren't paid on a per call. We did shifts, so we knew we could get paid. We relied on that. I think that's a big deal. I think you can't just say, and I don't know, I'm guessing, but you can't just say, well, they got paid hourly. It's really hourly plus the fact that, this was a primary portion of their income. I'm curious if these firefighters had done the same shift work, but it only was about 500 hours or 1,000 hours, whether that would be, similar. So I don't know, but, look, there are a lot of fire departments, I just want to say right now, and I'm just doing quick calculation, that require 12 or 16 hours a week in-house, like my fire department. That would only come to, if you did 12 hours in-house, that would only come to 600 plus hours a year. So here they're saying, well, 5 times that looks more like a job. And I do get that, Curt. I got to say, when you go to that extreme. So I'm hoping where you and I can urge other courts to read this decision narrowly to say it's not just shift work. It's shift work that results in 3,000 hours. Anyway, and the court, maybe lastly, or, as another factor, they look at, there's this volunteer form they're supposed to sign, and they didn't sign it. And so that makes it look like they're an employee. So they went through a lot of this. I don't know if there's any one you want to focus on, but they went through the four factors and said, these look like career firefighters.
Yeah, there's an awful lot of moving parts in this one. And first of all, when you say 3,000 hours, is that 3,000 hours in a firehouse? I totally agree. If you've got to stay 3,000 hours in the firehouse, you're an employee, unless you're dealing with an accommodation situation when people are living in the station or something of that nature. Right. But if I'm home in bed or cutting the grass or doing any of the things I do around my house and I'm available, and that's included in the 3,000 hours, I don't think there's another volunteer work out there that is comparable to volunteer firefighting. If you work at the local blood bank, if you volunteer at the library or senior citizen center, 3,000 hours would just be undoable. For firefighters, it's really not, but it depends on what you're counting in there. And I don't know what arguments the attorneys made. I don't know what arguments the judge heard. Sometimes you can make an argument the judge doesn't hear you, and that's, so maybe the attorneys made the argument the judge didn't hear him, whatever, but I didn't hear any discussion about that very issue, because you can't compare somebody who donates time for a charity, even your church, in a volunteer firefighter who very well may be available for several thousand hours a year without too much of a problem. So that's sort of issue number one. Issue number two is that when you're doing the 20% calculation, you're supposed to look at prevailing wage. And I don't know about, I'm sure in New York, Rhode Island here, I mean, you can't get a firefighter for $20 an hour, $25 an hour. You can't, you're paying upwards of that. Yet when the court looked at it, they said, well, you're working detail pay, so therefore we're going to use that detail pay as the prevailing wage. And I would think that a strong argument could be made, say, wait a minute, that's a discounted rate. That is not the prevailing wage for a firefighter. That is a detail rate that's used there. We should be using the prevailing wage in the state of Washington. And the prevailing wage, and I'm assuming now that the wage is somewhere $25, $30 an hour. Why is that important? Because I think the court said that it comes out to $4.71 an hour. Right. Well, you multiply that, and the factor that we use is 5. So you multiply the $4.71 an hour times 5. Now you're up to about $25 an hour. Now you're actually within the 20%. And then you get by with that. Okay. You didn't hear any discussion of that. There was no discussion of that. And again, I don't know what arguments the attorneys made. I don't know what, the judge heard, but there was nothing in the decision that addressed that. So I think there's a couple of concerns that I have. I'm hoping it gets appealed and maybe somebody takes a sharper look at those particular things, particularly the DOL's consistent. And I know, even when I lecture on this, I say this, I can do math, but I can't explain the DOL's position. The DOL says if you pay somebody $2 an hour to work a 10-hour shift, you have an underpaid employee. Right. If you pay them $2 an hour for a 10-hour shift, you have an underpaid employee. But if you give them $20 a shift, it's okay.
Right.
Okay, and that's the DOL has said that, and they didn't just verbally say it; it's in writing in numerous opinion letters that you can have per shift, because per shift, the way the regs are written, you can pay volunteer firefighters per call or you can pay them per call or similar basis. You can pay them pay them by the call or similar basis. So what is similar to per call? The DOL, by its own admission, has said that and it looks like, oh, I thought you froze up there. The DOL, by its own admission, had said that per shift is like per call, and now all of a sudden they're going in a different direction. So I don't know. It's a difficult decision to me. I've already reached out to my clients to let them know we got to kind of keep an eye on this, take a sharp look at how we're how our policies are going to be impacted by this, assuming that this case stands. So
right. And I do want to say, because you said something that really intrigues me, but the type of shift matters. For example, I hope I don't get too far off, and we'll move to the next case in a minute, but shifts matter. And there's something, at least in New York, and it is a federal rule too, where you're paid when you're on call or on, it's either paid on call is one thing. I'm going to explain it. I forget what the opposite is, but for example, if the federal test is, and state test is, if your movement is restricted, that you have to respond into your job in a certain amount of time and in a certain amount of distance, right? So for example, you said, well, we have three possible options here. Maybe they're doing the time in-house. Fine. If they're doing shifts in-house and they're getting paid and they're required to be there and can't leave, I get it. That looks more like an employment situation. If they're home mowing the lawn, but they have to respond if that's the rule, right? They get paid, right? They're required to respond because they're on a schedule, which is more what I would agree seems here. And they have to do the whole time. They can't, say, okay, I'm only doing half the shift, or I don't feel like going to this call. So they have to go to the call and they have to be there within a certain amount of time. Then their movement's restricted and they look more like an employee. So I'm presuming that's what it is. And this wasn't like you're just home, you can be around. If you don't want to go, don't go. Because then everybody would be saying for every 12-hour shift, oh, I was on, we didn't get any calls, but you still owe me the money. I would have gone had there been a call. So I presume the shift work is very much like, is very much like the restricted hours. You're either in-house or you have to be going to the call, one or the other.
Right.
So hopefully I didn't lose you a little bit here.
A little bit. It got a little chopped, but the voice stayed through, and I think you raise a really good point. Those cases that get into on-call time for employees really focus on the ability of the person to use their time for their own pursuits. I think that's actually the language that they use, the ability of the person to use the time. So if you are getting called 3 or 4 times a shift, a 24-hour shift that you're scheduled for, and you're getting called into work 3 or 4 times, 6 or 8 times, 10 or 12 times, or maybe once every 3rd shift that you sign up for, you're getting called in. There's a difference because there's things that you can do. There's I know when I was a safety officer in Providence, I was any second alarm. I was going on all these different things. I couldn't watch the kids because every single time I'd go to watch the kids, there'd be something, and I have to get my mom or somebody else to come over and do things. When you're on call to that level where you're getting repeatedly called, the time isn't available for you to do your own things. That's where compensation is required. On the other hand, if you're just like once every 3 shifts, you're actually going to catch a call or whatever, then that's a little bit different as well. So they take that kind of factor into account. So.
And I would beat up the court on the detail too, and we'll move on, but I would beat up the court on the detail because a paid firefighter would be doing that shift on overtime, right? And that time and a half is, I would have argued, is the actual rate, not straight time, because those aren't done at straight time presumably by a paid staff.
The regulations say that you should use the prevailing wage in either the jurisdiction or the region or the state or nationally. So you can use all of those. There was no discussion of that. They immediately went to a very low denominator there, $15 an hour or $20 an hour, and said it's not 20%. But I think that was again, whether the attorneys made the argument and the judge didn't buy it, or whether the judge misheard it or whatever, the judge basically ran with $15 an hour and $471.
Yeah.
So
yeah. I think the court got it wrong, but I understand, 3,000 paid hours effectively, that certainly does seem like a lot.